Every worker and employer should enjoy rights of freedom of association and collective bargaining, and protection against discrimination. What is the Labour Relations Act? The Labour Relations Act sets out the laws that govern labour in South Africa. Who is this Act for? The Labour Relations Act applies to all employers, workers, trade unions, and employers' organisations. The purpose of the Labour Relations Act is to give effect to Section 27 of the Constitution, to regulate the organisational rights of trade unions, to promote and facilitate collective bargaining at the workplace, to regulate the right to strike and the recourse to lockout in conformity with the Constitution, to promote employee participation in decision-making through the establishment of workplace forums, to provide simple procedures for the resolution of labour disputes, for which purpose the CCMA was established, to establish the Labour Court and Labour Appeal Court as superior courts with jurisdiction to decide matters arising from the Act, to provide for a simplified procedure for the registration of trade unions and employers' organisations, to give effect to the public law obligations of the Republic relating to labour relations, to amend certain laws relating to labour relations and provide for incidental matters. So what does all this mean? The Labour Relations Act safeguards workers from unfair labour practices. This Act has been put in place to protect the privileges of all workers, defining and defending the rights of employers and employees alike. All workers in South Africa are entitled to a safe and healthy work environment, decent wages and working hours, protection from unfair dismissal, membership of a trade union. Employees and employers cannot be discriminated against because of membership. Strong trade unions and employer organizations are important for effective collective bargaining. Unions registered with the Department of Labour are governed by constitutions that embrace the principle of calling for a ballot before holding a strike or lockout. Organizations do not have to be registered with the Department of Labour, but registered unions have more organizational rights. Unions are expected to rule against racial and gender discrimination within the union. Trade union representatives have the right to do the following without disrupting work activities: enter an employer's premises in order to recruit new members, hold meetings and conduct ballots at the workplace, deduct trade union subscriptions from members' salaries, ask employers for relevant information as long as it is not legally privileged. If a union has organizational rights in the workplace, its representatives can oversee various functions. They help employees in grievance and disciplinary hearings. They monitor employee compliance with labour laws. They report on any contraventions of the Act. The Labour Relations Act succeeds in elevating labour rights to human rights. In short, the Labour Relations Act No. 66 of 1995 ensures that every person shall have the right to fair labour practices. Workers shall have the right to form and join trade unions, and employers shall have the right to form and join employers' organizations. Workers and employers shall have the right to organize and bargain collectively. Workers shall have the right to strike for the purpose of collective bargaining. Employers' recourse to the lockout for the purpose of collective bargaining shall not be impaired. Never before has such a vast number of workers enjoyed such a wide range of rights.